Okay, here we go. So just a little bit about me. I don't know many of you, so you don't know me. So I am Abigail Lipson. I'm the owner of High Fidelity Properties. We're a residential property management company. I've been in property management for 15 years. I, like you, am a licensed realtor, but my focus is property management and not sales. And then I'm also a rental property owner. I own several duplexes, and my properties are actually run through my property management company. And then just a little bit about my company, High Fidelity Properties. The company is 10 years old this year. Our specialty area is single family homes, duplexes, fourplexes, and condo units. We currently manage 120 doors. And as you can see, we offer the full suite of residential property management services. Okay, Landlord Beware. So when I think about it, I give myself the heebie-jeebies because I know that most landlords are actually self-managing landlords, and they don't know what they don't know. And what they don't know can be costly and dangerous. Costly in the way of lawsuits, dangerous in the way of health and safety for tenants. Landlords don't go to landlord school, and I'm aware that many of them don't even know some of the most basic code compliance that they're required actually to be abiding by. And then just a quick disclaimer, I'm a realtor, I am not an attorney. And so I'm not going to be interpreting the information. I'm just going to be sharing it based on the code and so forth. And so should you have, if you're a landlord, if you have clients who are landlords, of course they should consult an attorney when they have questions. Okay. So much of what we're going to be talking about is coming from the Texas Property Code. Allison's going to go ahead and share that link in the chat box for you. If you're looking for some fascinating reading, you'll be able to open that up yourself and take a look. What you can see here is just the very beginning of that document. It's a huge document. And no, it is not fascinating reading. I'm joking. It is some of the worst reading that you'll ever do. And yet, it's my job to know what's in that code. Okay. So before we even dig into the details, let's just talk about some of the most common tenant lawsuits. These are not particular to Texas, these are national. But what these indicate is that these are situations where the tenants knew their rights and they pursued them and they won against landlords. And so keep these in mind as we go through the content. So not repairing hazardous conditions on the property, wrongfully withholding security deposits, fair housing and discrimination cases, injury on the premises where the landlord knew about it and didn't repair it, right to privacy, unlawful eviction, illegal lease clauses, breach of covenant of quiet enjoyment, and retaliation against a tenant when the tenant complains about that violation. So we're going to start off by talking about security devices and door locks, but before I take you to the next slide, we're going to actually start with our very first poll. So when does a property need to be rekeyed? And this is a multiple choice question. So answer all that apply. Come on, guys, you can do it. There we go. Still got a few more. I know at least one person is driving. We will exempt you from answering the poll. All right. It looks like that's going to be, oh wait, we just got one more. Okay. So as you can see, pretty much everyone thinks it's before a previous tenant moves out, and then some thought all of the remainders. And so the answer is it's actually all of those cases except after a listing. So yes, when a tenant moves out, you have to change the locks, but also when an owner moves out, you have to change the locks. A lot of owners don't realize that because they think, well, even if I change the locks, I'm going to get a copy of the key. So why do I need to change the locks? But that's not the case. They do have to change the locks. So anytime there was a prior occupant, you change the locks. Another area where landlords get themselves in trouble, they don't realize, is that they actually have to have two sets of locks on the door. So one is a keyed doorknob lock or deadbolt on the exterior door. So meaning you can access it via key from outside. And then the second one is a keyless deadbolt where you cannot access it from outside. A lot of landlords miss that piece of it. And when it says exterior doors, that actually also refers to the door that leads into the garage. So that also has to have both of those locks. There have to be peepholes on exterior doors. If there isn't, if it's a glass door, that's a different story. You can see up, but there have to be peepholes. And then if there's a sliding door, there have to be two things. One, a pin lock, which you can see in that photo. And then the other is either a handle latch, which, is like a little lock, or one of those security bars. And then windows have to have working window latches. Next, smoke detectors and carbon monoxide detectors. So I think we all know that there have to be smoke detectors in the property, but sometimes landlords don't bother to check to make sure that those are working. And so it isn't just that you provide a smoke alarm, you actually have to provide a working smoke alarm. So it's useful to actually check them and maybe even just to change the batteries in between tenants to make sure that they're getting the best working detector possible. And then as of about 3 years ago, Austin started to require carbon monoxide detectors if there's gas, fuel burning appliances, or an attached garage at the property. And so many landlords know about the smoke detectors, but they don't know about the carbon monoxide detectors. In addition, there are specific requirements for where and how they're placed, and that information is provided in the code. Now for detectors as well as security devices, we use a third-party company that actually knows all of the code compliance that we just talked about, and they handle it for us. And so that's really helpful to make sure that we are always in compliance. Okay, a big topic is service animals and emotional support animals. This really, frankly, could be a topic unto itself, but I just want to cover some of the most basic code compliance issues. So just to remind us of what those terms are. So a service animal under ADA is a dog or a miniature horse. It's only those two animals, and they are trained to perform tasks or do work for a person with a disability. And the work that they're trained to do has to be directly related to that person's disability. An emotional support animal provides support to a person suffering from a mental health illness. And so at the top of the top bullet, I refer to Texas Realtors Form 2226, general information for landlord regarding assistance animals. If you're helping your client to lease a property, it's really helpful if you provide this document to them because it explains these terms and also gives them an idea of what they can and cannot do. So some of the things that they can't do, they cannot deny one of these animals, even if they have a no pet policy, just simply not allowed to. They also can't use a pet agreement. They're not considered a pet, they're considered an animal. What we do so that we can keep track of those animals is we actually put them in the occupant section of the Texas Realtors lease form. And so, we put all of the tenants as well as like if there's kids, and then we'll put that, say dog's name and then in parentheses ESA, so that way we keep track of it. You also can't charge a pet deposit, again, because it's not considered a pet. That said, should the animal do any damages, the tenant is absolutely responsible for those damages. In addition, landlords must make reasonable accommodations. So an example would be if they have a home insurance policy that prohibits certain breeds, which is not uncommon, maybe they don't allow pit bulls, even if the tenant or the applicant has a pit bull, if it's an emotional support animal, you can't restrict. And so a reasonable accommodation, would be to get different insurance. And that would be the best course of action. There can be some exceptions, but definitely you want to consult an attorney if you wanted to try to have an exception. The best rule of thumb is to accept the animal if it's a legitimate service animal or emotional support animal, but some of the exceptions could include an undue financial burden. I remember reading about a situation where it was a multi-unit complex and the applicant or the tenant with the ESA requested that the owner put up a fence. As we all know, a fence could be many thousands of dollars, and that could be considered an undue financial burden. So they'd want to check with an attorney about that. Another case would be if the animal poses a threat to the health and safety of the other tenants, or if the animal would cause damage, and that would have to be based on the actual conduct of that animal, not based on the breed. So here is an actual example. This just came up a couple of days ago on Facebook. So this is in a property manager Facebook group, and this situation kind of blew my mind. So this woman is a property manager, and her daughter has a bunch of disabilities and has, it's not clear if it's a certified service animal. She talks about it as a therapy animal. It is certainly an emotional support animal, and she has the proper documentation for it. And the property manager for this property is saying that she has to pay a pet deposit, and she keeps saying it's because in case the animal causes damage. So a property manager should certainly know better than this, but what she goes on to explain in the comments is that this property manager has only been on the job for 3 months, and she's just following what the landlord is telling her to do. So in this case, the landlord absolutely has no idea what's appropriate and is basically demanding a pet deposit. So here's a case of a bad landlord just simply not knowing what the rights are. And so I believe that this will get resolved because they're just so completely in the wrong in this case. Okay, next up, repairs. The main issue here is that you have to repair issues affecting health and safety. Now that might seem really obvious, but we are all well familiar with some landlords, and these types of issues often don't get taken care of. And sometimes the landlord will think, well, I want to repair this, but they're behind on rent, and so I'm going to withhold it until I get the rent. But if it's an issue that affects their health and safety, we just simply are not allowed to not do the repair. On the other hand, there are exceptions where landlords do have some rights. So a tenant cannot withhold rent for a repair issue that does not affect health or safety. And a landlord is not required to make non-emergency repairs if the tenant is past due on rent. And in that case, the landlord could use that as an incentive to the tenants to get themselves caught up on their rent by letting them know that they'll take care of the issue as soon as they have gotten caught up. Now here we have another, in this case, crazy landlord situation. This was just 5 days ago on Nextdoor. This is in Austin. And this landlord, there were a bunch of code enforcement actions against the landlord. The landlord was pissed about it, and they actually broke the tenant's windows and door, as you can see in this picture, and they beat this woman's daughter. So she mentions that there is an ongoing criminal investigation and civil actions pending. So of course, this is not safe. The windows are broken, the door is broken, but the landlord is refusing to make repairs. And so this woman was reaching out because she's asking, does anybody have a door? Can someone help me? Like, we're not safe here. And so she did reach out to the Austin Tenants Council, and of course they were shocked. They said it's the worst case they'd ever seen, and they were quite surprised that the landlord didn't get arrested. As a side note, I asked this woman if she had renter's insurance, because here she is looking for resources, and renter's insurance most likely would have been able to help her. She did not have renter's insurance. So I pray the next place she moves to that she will get renter's insurance for herself. So again, we see it, and this is in Austin, a landlord who clearly has a lot of issues, but not taking care of tenants, not doing anything. Oops, go back. It's time for our second poll. This is relating to late fees, and hopefully you didn't see that. So the question is, does Texas put a limit on how much landlords can charge in late fees? Texas is a very landlord-friendly state. Waiting for just a couple more. Okay, so almost half and half, but slightly more say that Texas does not put a limit on late fees. And the answer is yes, Texas does put a limit on late fees. And this was actually only instituted a couple years ago. This did not used to be true, but it is now true that for a complex of 4 units or less, there's a max of 12% in late fees that you can charge. So for example, if the rent is $1,000, which in Austin is probably hard to come by, but for easy numbers, if the rent is $1,000, the max you can charge in any given month is $120. If it's more than 4 units, then the max is 10%. So a lot of landlords don't know that there are late fees, and a lot of realtors don't know that. So that's sort of good to be aware of. In addition, rent must remain unpaid for at least 2 full days before you can charge any late fees. If the tenant is aware of their rights and they pursue it, then the landlord would have to pay $100, 3 times the late fee collected in violation, as well as attorney fees. Next, we'll talk about security deposits. This too could probably be a whole subject unto itself. There's a lot that goes into this. But the main thing, well, there's a couple main things, is that security deposits can't be used for normal wear and tear. Now, I'm going to guess most of us know that, but a lot of landlords don't, because there are a lot of lawsuits about security deposits being wrongfully withheld. And so when it comes to normal wear and tear versus damages, it's very easy to look this up on Google and find documents or examples that will show what the difference is. And this, is useful to supply to any landlords that you're working with. We actually supply it to our tenants, so that way they will have an idea of what to expect. Couple examples. So let's say there's carpet and there's a stain on the carpet, so that would be considered damage. But if there's a well-worn pathway from the door to the bed, that would be considered normal wear and tear. If there's a bunch of tiny nail holes in the wall from hanging pictures, that would be considered normal wear and tear. The standard we use, which I think is probably the typical standard, is a 6-penny nail, which is a 2-inch nail. So anything that size or smaller, we consider normal wear and tear. Anything bigger than that would be considered damage. Another area of concern for landlords is they have to return the security deposit within 30 days of the tenant moving out, and they have to provide a full accounting of whatever deposit they withheld. If the tenant goes after them because they violate this, they have to pay $100, 3 times the amount of the deposit wrongfully withheld, as well as attorney fees. The exception to this is if a forwarding address has not been received from the tenant, then that 30-day clock doesn't start until you do receive it. Allison, who deals with turnovers, she knows that I'm actually pretty obsessive about security deposits, because during our busy season, we have, 20, 30, 40 leases turning over. And it's a lot to keep track of. And if tenants are going to know something, this to me is probably the thing they're going to know about their rights. And so I am very careful never to run afoul of this. Okay, a couple of other general code compliance issues. So landlords get in trouble when they don't give proper notice in writing. So for example, you cannot verbally terminate a lease. That must be done in writing. You can't lock out a tenant. Now, this might seem really obvious, but some landlords actually don't realize this, particularly because in commercial cases, you can lock out a tenant when they haven't paid their rent, but you absolutely cannot lock somebody out of their home. Another area is not letting tenants out of the lease in certain special situations. So one of them is military. So if the tenants are in the military and they're being deployed, then they get to be let out of the lease. If there's family violence by an occupant of the property, or if there's sex offenses or stalking that take place on the premises. In all cases, you can require documentation. So in the case of military, we're likely talking about military papers. And then most likely if it's family violence or sex offenses or stalking, then you're talking about a police report. Okay, now we're going to talk about evictions. This is a huge topic also. First, we're going to start by talking about evictions in normal times. Then we will talk about evictions during COVID, because that's a whole different beast. But let's just pretend that evictions is regular times and evictions are allowed. So first off, well, let me just say, landlords get themselves in all kinds of trouble around evictions. There's so many things you have to know. And oftentimes they run afoul at different points along the way. So first off, in Texas, you have to provide a minimum of 3 days notice to vacate. If you are helping your clients with this in any way, it's useful to give them this form, this Texas Realtors form, notice terminating right of occupancy. In there, you can specify how many days that you're giving them. You can give them more time, you just can't give them less than 3 days. You also have to deliver that notice in a particular way. You have a few options, but for example, email is not one of those options. You can put it in the mail. I don't necessarily recommend that because then you don't know when it arrives and then you don't know when that 3-day clock starts. Personal delivery, I don't necessarily recommend that one either because the person receiving that notice is not going to necessarily be so excited about it. And then the third option, which is what we do, is we post it inside the property. So we would post it inside the front door. The only exceptions to that, by the way, is that if the door were deadbolted and you couldn't get inside, or if you believed that your physical safety was in jeopardy, then you'd actually be allowed to post it on the outside. We've had to do that in a couple of instances. And what we do just to sort of prove that we have posted it is we'll take photos where it's very clear, this is the house, here's the house number, we have posted it. So another interesting situation that can come up is that sometimes after you have filed your case, the tenant will pay partial rent. And the question is, should you receive that? Should you deposit that? And I've actually talked to a couple of different attorneys about this, and they say it depends. And what it depends on is the judge. So some judges, if they know that you deposited that money, they will actually like end this case and make you start over. Other judges won't do that. We have a case right now where we did actually receive a partial rent payment. Our tenant put it in a Dropbox. He's behind 3 months in rent, but he paid part of 1 month's rent. And so we have that check, but we haven't deposited it because we don't know how the judge will take that. And so we're waiting to find out. Let's say that the landlord gets a ruling in their favor and the tenant is to be evicted, but the tenant doesn't leave on their own. So the constable will come and remove the people, but the constable will not remove the belongings. That's actually the job of the landlord, to remove everything that's inside. Well, there are certain requirements for how you remove that, how you package it up, how long you have to keep it outside, like you put it on the lawn, how long it has to be there. And so this is, this is an area where a lot of landlords just wouldn't even realize that there were any sort of requirements of them about how they get those materials out. So we've never had to go this route, but we actually work with a junk hauling company who does a lot of just junk hauling for us during tenant turnovers, but they do tons of evictions and they know exactly how to do this properly. So that is who we would use, junk hauling company, to handle that for us. Okay, before we go to the next slide, evictions during COVID, we're going to put up our third poll. Is it possible to evict a tenant in Texas during COVID? %68% have voted. So we can get a few more in. Okay. So most of you think that it depends. But a fair chunk of you, 42%, think no, you cannot evict during COVID. Well, the answer is, it depends. So that woman doing that, you know, with the big headache, that's me. And that's because evictions during COVID is, you know, really confusing and ever changing. It's a really interesting situation. And it's one of the more intense things that we have to, as property managers, keep on top of. So the ordinances and the moratoriums vary based on federal versus state versus county versus city. Here we have multiple counties that we deal with, and they each say different things, and they have different dates, and they have different specifications. One thing is that regarding federal, the property cannot have a federally backed mortgage or participate in a federal housing program, such as Section 8. If that is the case, that the landlord has, say, a federally backed mortgage, then you can't evict them. And that's what the federal government is saying. Now, there's a couple of different moratoriums in effect that affect us. So there's the CDC moratorium. Originally, that ended January 31st, but it's been extended to March 31st. And the latest relief bill is looking to extend that till the end of September. So that'll be interesting. And the purpose of the CDC moratorium has to do with health. They're concerned with the spread of COVID-19. So their goal is to try to keep people from getting kicked out and then having to move in with other people and then being in close quarters and more easily spreading COVID. That's their purpose. Whereas Travis County just simply is trying to keep their residents in place. It's not specifically related to getting COVID. It's, you know, it has more to do with just not having people homeless, not having people out on the streets. So Travis County has constantly, you know, extended their moratorium, and currently it goes until April 1st. Now, the requirements or the specifications around each of these is different. So the CDC moratorium says that you can evict people for non-payment of rent unless they make a particular declaration, which is below, and they have to declare, the tenant has to declare 5 things, not one or the other, but all 5. The first one is that they've used all best efforts to obtain all available government assistance. The second one relates to income. The third one, the tenant's unable to pay full rent due to loss of income. 4, the tenant is using best efforts to make timely partial payments, and eviction would likely render the tenant homeless or force them into close quarters with others. So this is the form that they would have to fill out, or basically that they'd have to sign, and that's all of the things that they're declaring. That's available on the CDC website. A landlord doesn't have to tell the tenant that this exists or provide this form to them. That is on the tenant to know their own rights. But if they make that declaration, then that in essence puts the kibosh on the eviction suit when it comes to the CDC moratorium. You can apparently contest this to the judge if you knew that some of these things were not true, like if the tenant, you knew that they had not applied for assistance for rent. But I don't know, that may depend on the judge. I'm not sure if we have examples of how that has fallen out. Travis County, on the other hand, they don't care about this declaration. They just say you cannot evict for non-payment of rent. So the eviction case that we have going right now, it's in Williamson County. If this tenant were in Travis County, we'd be stuck for now. So as you can see, a lot to know, a lot to keep track of. Not so easy to keep track of. Kind of a full-time job. All right. Next, we'll talk about fair housing. Now, this is not the Texas Property Code specifically, but fair housing is obviously a big issue. All of us as realtors are bound by the Fair Housing Act, and we probably know exactly what it includes, but useful to remind ourselves. So it prohibits discrimination based on race, color, national origin, religion, sex, familial status, and disability. But some cities, and Austin is one of those cities, will add other prohibitions. So in Austin, you also cannot discriminate based on sexual orientation, gender identity, and student status. I'm sure a lot of landlords would love to reject applicants who are students because they believe that they will trash the property. But in Austin, since we have such a high student population, that is not allowed. There are some exceptions for landlords. If it's an owner-occupied building with no more than 4 units, then they actually are allowed to discriminate. Or if it's a single-family home rented by the owner without the use of an agent. In that case, they can also discriminate. But if you as a landlord or as a realtor are helping your client with the leasing, then you are not allowed to discriminate, and therefore they are not allowed to discriminate. And if they want you to, you can't do it. And if they insist, you probably shouldn't be working with that client. So this is not a fair housing thing, but useful to include here. In Texas, unlike in many states, we do not actually have to accept Section 8. That may change at some point, but that's the way that it is right now. Another big area has to do with criminal history. So this one is actually really interesting. And I'm aware based on phone calls that I get from realtors that a lot of realtors don't actually know about this. So about 5 years ago, HUD made a ruling regarding discrimination and disparate impact cases. So this document on the right that's the first page of a 10-page document, and it's that ruling that HUD put out. And what they determined is that people of color are disproportionately convicted of crimes. And so if you have a blanket policy where you reject applicants who have criminal histories, then you are discriminating. And this document says that you therefore cannot do that. In other words, you can't have a blanket policy rejecting criminal history because that's discriminatory. And so in most cases, it's just going to be safer for a landlord to just consider most criminal history to be irrelevant. So for example, if it's a DWI or marijuana possession or speeding ticket, like these are just not things that you're going to want to deny based on them, because you'd have to prove that it would affect the tenant's ability to be a good tenant, and chances are you're just simply not going to be able to prove that. There could be exceptions, and so that would be a good time to consult an attorney. This document does, however, lay out 2 specific exceptions where you can reject an applicant outright, and that is conviction for drug manufacturing or conviction for drug distribution. So that's basically the only cases where you could say, no, thank you. Some exceptions could have to do with protecting other tenants. I'm not exactly sure what those examples could be. Maybe it has to do with like sex offenders, but again, I'm not sure. We have not had to deal with that personally. Okay, so those are the main areas that I wanted to cover. I'm bringing back up the tenant lawsuits that happen because I think it's useful to now see based on what you've just learned, what things are actually coming up. So landlord not repairing hazardous conditions. We saw an actual case of that happening in Austin, but that's a common thing. And remember, these are tenants who know their rights and have pursued them. Wrongfully withholding a security deposit, lots of cases where that could happen. Fair housing and discrimination. Injury on the premises, if the landlord knew it and didn't repair it, right to privacy, unlawful eviction, illegal lease clauses. By the way, an example of an illegal lease clause would be if you said that you didn't accept ESAs. You're not allowed to say that. Breach of covenant of quiet enjoyment, or retaliation against a tenant when the tenant complains about a violation, such as, for example, threatening a lawsuit, threatening to increase the rent or reduce services, things like that. So there are tons of resources online, but here are a few good ones. We're going to go ahead and put those in the chat box for you. And then that is the main content that I wanted to present. We're going to have a Q&A in just a couple of minutes, but I just wanted to take a moment to tell you about our realtor referral program because it's something that we offer to realtors. It's a robust program. We get a lot of our referrals from realtors, and so this is our way of being able to give back to you guys. So when you think of a referral program, yes, we offer referral fees, and there's 3 different tiers. Now, I want to make it clear that this is based on the number of doors that get sent our way. So if you send us a client with 5 properties, then that is 5 referral fees. And so at the top level, that's where, say, your client buys a rental property, it's vacant, and you just send it on over to us, and we do the initial leasing and the property management. The second tier is where, say, your client buys a property that is vacant, and you help them lease it. Maybe you do that as a gift to them, or they request that you do it. So in that case, you do the initial leasing, then you send it over to us. And the last scenario is if we're just going to lease the property, the landlord's going to manage it themselves, but they would like some help finding a good tenant, then you get a referral fee for sending those folks to us. We offer a free analysis and review to you. And I want to make sure you know that this has nothing to do with whether or not your client signs up with us or even if you end up sending them over to us. This is just a free service. And it's great for you because we make you look like a hero to your client, right? Because in essence, they're getting 2 realtors for the price of 1. I'm happy to help out in any way that I can. So if your clients are considering properties, send them my way. I will take a look and make sure that the homes will make a good rental. Not every house makes a good rental. Not every neighborhood makes a good rental neighborhood. And so we have a lot of experience with this. Happy to review it for you. What rent can they get? We will run comps. You can run comps, but how great is it that you have 2 people running comps and then you can confidently present that information to your client. We'll also make property visits, again, to see, is this a good rental property? Should they go forward with purchasing this? I have done this with realtors where I've gone with them to review properties. We're also just an additional resource for you should you have any questions. I actually hear from realtors on a quasi-regular basis who have questions for me relating to property management or rental investing in some way, shape, or form. We have the rental report, which is a monthly newsletter. It is specifically all about rental investing, property management, that type of thing. And it's for realtors, and it's to help you position yourself as an expert. So Allison will or has put that link into the chat box. And so it's just great. We're not going to spam you. It's just going to be once a month. We're going to send you really good information. In addition, we're offering these free webinars. We've got a whole bunch of topics. Allison is going to go ahead and put up the next poll. I'd like to know which of these topics are you interested in, and please check all that apply. And this will influence the webinars that we present to you. Well, this is really interesting. It's not necessarily what I expect, but this is great. This is great. So you will see this in just a moment. So almost all of you are interested in landlord rights in Texas. So that's great. So actually, I will make that the priority for the next webinar, but there are a couple of other high interest topics. So Allison will take a screenshot of this, and I will definitely be keeping this in mind. Thank you so much. This feedback is great. Last, and maybe most important of all, is peace of mind. And what do I mean by that? So I know that realtors have a concern about sending their clients to property managers because we're realtors too, and you're afraid that we'll steal our clients. Valid concern, but I'm here to assure you that that would never happen with us. As I mentioned, we get a lot of referrals from other realtors, and so I know that you are vital to our success. I would never bite the hand that feeds me. It's just, in my opinion, it's wrong. It just doesn't, my values don't support stealing clients. And on top of it, at the beginning, I mentioned that my focus is property management, not sales. I do not enjoy doing sales. I don't do sales. So you never have to worry that I'm going to try to steal your client. We always send your clients back to you when they're ready to buy or sell. And I actually have clients reach out to me on a quasi-regular basis about this. They'll be like, hey, how does it work? Do we have to work with you? I was like, no, absolutely not. You should go talk with so-and-so. When I know that agent, then I will actually reach out to them and say, hey, your client's considering selling or looking to buy, so you might want to give them a call. I'm in touch with my clients a lot. You know, I send them monthly statements, and there's lots of reasons why we're in touch with them. So we're top of mind for them, but we make sure that you remain top of mind for them as well. And so that's our referral, realtor referral program. And now it's time for a Q&A. All right. Let's see. So you're welcome actually to unmute and ask questions if you want to. And in the meantime, I'm gonna go ahead and take a look through here. Okay, so first question, what if a person has more than one ESA? Do you have to allow multiple ESAs? So my best understanding is that the answer to that is yes, because it's based on like a doctor or a therapist saying that this person needs that. And if you have proper documentation, then I believe, as far as I know, the answer is yes, that you have to take more than one emotional support animal. But Mark says new directives. Hey, Mark, can you explain what you mean put out?
Yeah, HUD put out, because this is so confusing and so many people have questions about what is actually classified as a ESA and what kinds of questions are you allowed to ask and what types of certifications are approved. Because of the abuse of this kind of situation or provision, they have said a couple things that are different. And I think one of them is, I think they limit the ESA animals to 2. I'm not sure about that one. But one thing that I do feel comfortable speaking about is that in the past, they're basically getting rid of these online services where you just call up and speak to a therapist for 15 minutes and then get a certification. The new ruling requires that the therapist or doctor, whoever that professional is, who is making the basically prescription that you need to have an ESA, is that they have to have a long-term knowledge of your condition and have already been giving you therapy for a while. And then their prescription comes out of that historical knowledge of you and your condition and the prescription that you need an ESA to help you. Whereas before, you could just get these things from an online service. My sister is a professional therapist, and she was offered to take a position at one of these online places, and she said absolutely not, because she saw that it was really perfunctory or even phony, because you didn't really know these people and you haven't come to understand their psychological situation and therefore their need to have an ESA. And she's a big pet lover and is a promoter of this, but she just said it was such baloney. So HUD in January came out with these new rules that are a little bit more explanatory about this and basically pretty much eliminating these online services as a valid reason to have one. Because in many ways, you can even consider every pet is an ESA. That's why you get a pet, because you're looking for a little bit of enjoyment and another person or thing to be around you. So it's too much of a stretch to have this be a one-time speaking with a therapist and then them saying, oh, okay, well, after 15 minutes of talking to you, I see you obviously need an ESA, and so I'll give you that designation. So.
Thank you, Mark. Yeah. So we actually, there's a third-party company, petscreening.com, and we require all of our applicants to fill out a profile there. And then this pet screening company will actually, they do a number of things, but they will check for any of the documentation for ESAs and determine if it's legitimate or if it's fraudulent. And they do actually catch fraudulent cases. And so that's a great service. Okay, so with COVID and the moratorium on evictions, what is a landlord to do when the tenant is not paying the rent and not answering messages? So the federal government authorized $25 billion in rent assistance, and about 1.3 billion of that, I believe, is going to Texas. And starting on Monday, Texans can apply to get rent assistance, and the landlord can actually apply on behalf of the tenant. Now, the tenant has to co-sign, but the landlord can. And so I would say, like, if the tenant is going AWOL, and you cannot evict them, and they're in Travis County and you really can't evict them, then probably seeking rent assistance is going to be the best way to go. Gracie, if you have any other questions about that or any other comments, feel free to pipe up, but that I think is the best way to go. And actually, I told you about this eviction scenario we have in Williamson County. It appears that even after tenants have moved out, that you might still be able to collect rent assistance for back rent. So we're going to go that route as well.
I see. But in my case, they're not even calling me back. So I know they will not sign anything. Unfortunately, they are in Round Rock.
They are in Round Rock?
Yes.
Oh, well then Round Rock is one place where you can evict them. Unless they make a declaration or there's a federally backed mortgage. But if those don't apply, then you can file an eviction.
Yeah, it is a conventional loan, so I don't think it will be under that category. But also, we had another case back in May that the tenants trashed the place. So we filed with the court, and we're still waiting to hear back from the court. And it's been like 6-7 months.
Yeah, well, there is a backlog, I believe, but if it's for reasons other than non-payment of rent, you absolutely should be able to move forward with it. But it could just be that they're backed up.
Yeah.
But if you file for rent assistance, maybe at that point they would be willing, like you're just saying, hey, we just need your signature, and then guess what? We're going to get money for you and you will be all good, because if they don't, when their lease runs out, you don't have to renew them and they still owe that rent, and you could still evict them at some point or another. So it's much better for them. So if you communicate with them and let them know, hey, here's a really great solution, I just need a signature, and guess what? It means that you won't be evicted, all these other things, then maybe they'll get in touch. I mean, it's certainly worth a shot.
Yeah, I appreciate it. Thank you so much.
You're welcome. Okay. So what about by courier, meaning delivering a notice to vacate? So that's a good question. It says personal delivery. I don't know if a courier counts as personal delivery. It doesn't say that actually in the code that I'm aware of. So I would presume no, but
Okay.
But I could double check that in the code.
Thank you.
Gracie also asked, what if the realtor owns the property? So I'm not sure the context, but as a realtor, you are subject to fair housing. And so fair housing always applies to a realtor. Oh yeah, so it is relating to that. So no, yes, you can exclude certain people. You can discriminate where fair housing is, like if you don't like attorneys, you can discriminate against attorneys, for example. But you cannot, you have to allow students, for example. You can't discriminate on anything fair housing wise.
I see. Yeah, my only pet peeve is sex offenders.
Say it again? Oh,
my only pet peeve are sex offenders, because sometimes I go to the property myself or my daughter who's beautiful, so we cannot take chances.
So I would ask, that's a case where I would ask an attorney. I feel like that might be the case, relating to criminal history, if it's a licensed sex offender, because the safety, safety could be an example. So that would be a case where you want to ask an attorney.
Yeah, you're very helpful. Oh, and something unrelated, I'm sorry. Do you do property management in California as well?
No, just in the Austin area.
All right, thanks.
So Claudia asked, if the tenant leaves before the lease term, do I need to return the deposit? So it depends. So it depends what it says in the lease. So for example, there are, you might have an early termination fee. And it may say that in your lease that the tenant is required to pay for all expenses relating to releasing due to an early termination. So you don't have like a de facto right to not return the deposit, but chances are you get to keep it because actually the tenant is still on the, like, is responsible for the lease until either it ends or you replace. So that could be used for future rent, like for the next month or whatever. Hopefully, Claudia, that answers your question. If you have anything else about that, let me know.
Thank you. It does. Thank you.
Okay. Tim, yes, I will be sending out a copy of the presentation. So don't worry about that. Okay, Claudia also asks, how do you handle a situation when you believe someone who is not on the lease is staying there? So that's a violation. So if you want to evict them for that, you could, but if you don't want to evict them, then you would want to get the boyfriend onto the lease, for example. So you try to, so you could ask them to fill out a rental application, like you try to qualify them, and then you would want to put them on the lease.
Okay, sure. Do I need proof that he's staying? Like, I believe he is, but I'm not sure. Should I have, how do I handle that? If I go with a judge and he's asking for proof that he is actually staying there?
I mean, I think it would be hard to provide proof unless you know, hire, like staked out and were to, you know,
Okay.
like get documentation of that. But
That's what I thought. It's hard.
But here's the thing, you know, not everybody is necessarily going to have a problem with that. If you call them out and say, hey, I know it really looks like your boyfriend is living there. Let's just qualify your boyfriend and get him on the lease. You know, like, I mean, maybe they'll fight you and maybe you don't have a lot of recourse, but I mean, we've had situations come up where we just approach them and they're like, oh yeah, okay. And then they comply, you know?
All right, thank you.
Yeah, myself, if they're paying on time, there's not a bunch of cars outside, I just let it go because why?
Say that again?
If they are paying on time and there's only 1 or 2 cars outside the house, sometimes it's more trouble than it's worth, as long as you don't see like a whole hotel going in and out.
Yeah, sure. I mean, if all else is good, you know, you don't have to rock the boat.
Yeah, it kind of bothers me, but sometimes you just have to pick your battles.
Right. We've had a lot of interesting, I could do a whole webinar just on stories, right? Of things we've had to deal with in unauthorized occupants and so on. We've actually,
please do. I think you will have a really big audience.
Yeah, maybe so. We had a case, I won't go into the details, but we had a situation where a son-in-law who was a US citizen actually applied and was approved for a property, but it turned out that his illegal immigrant in-laws were living in the property. He actually rented it for them. So that's a whole story that actually had a happy ending, but anyway. Okay, so Rob asks, is there an average and max pet deposit per animal? I don't know if there is a max pet deposit per animal. Some companies will charge like the same fee for all pets. We actually do a tiered system because we use this pet screening, this third-party company, and they come up with what they call a FIDO score, like a FICO score, but it's a FIDO score and it's 1 paw to 5 paws. And so for pets that score 4 to 5 paws, we charge less of a deposit because that's considered lower risk than for somebody for anything else has 1 paw. So yeah, but you want to do it consistently, Sarav, whatever you're doing. If you have multiple properties,
sure,
you want to have a consistent policy.
All right, thank you.
Okay, Tim asks, is there a difference for a Wilco County tenant who is not paying rent for many months and the lease has gone to month? Can the tenant be asked to leave when we sell if they're living month to month and not paying rent? So if they're living month to month, you can give notice. So maybe, Tim, you can help me understand what your actual question is, because you don't have to allow them to keep living there.
Yeah, so I guess because the lease is expired, the question is, can they be evicted? Is it even an eviction? Were we talking about eviction, or are we just talking about giving them notice that the lease is over and you're out of here?
So you can, my understanding is that, so you can ask them to leave. You can just give them 30-day notice and they have to go. But if you're trying to collect rent, you should be able to file a case for rent, you know, that they haven't paid. I mean, that's a violation of their lease, that they haven't paid their rent. So that's not eviction, but that's for, you know, money's owed.
Yeah, I mean, that's the back payment of $15,000 in rent is a separate issue. I guess, you know, we're getting ready to sell the house now, or my client is. And so we're just trying to figure out, do the COVID eviction restrictions apply to someone who's been claiming COVID and that COVID related issues and not being able to pay their rent for, you know, the better part of the last year? And so are we held to COVID restrictions and saying your lease is over, you're living month to month, there is no extension to the lease, now you need to leave?
So there are some states that actually don't let you just simply terminate a lease with a tenant, like, or just not renew. But Texas is not one of those states. In Texas, if the lease is up, you can not renew them. You don't have to give them a reason. You're allowed to not renew, like legitimately not renew them. Like if your lease says you just have to give them 30-day notice, you can give them 30-day notice.
And there's no COVID overlay on that?
No, no.
That's great news. Thank you.
You're welcome. Yeah, you're not required to keep them in place. Yeah. Okay, does anybody else have any questions?
Yes, I do have. Hi, Abby. As a realtor, once we find an investment property for our client, the next thing is they're trying to get some help. And I'm also willing to do some help, but how far and what is the boundary? Like, how far can we help in getting them a tenant? Even though the owners want to manage the property, they say they could use any websites like Zillow, Property Manager or something, and they just ask me to see if I can show them the property, not much of talking to them. Will that be crossing the boundary of a property manager? Where do we stop?
So I don't actually think it's a boundary issue, meaning that if you want to lease the property for them, like if they want your help with leasing, you're certainly welcome to do that.
Oh, okay.
Yeah.
So I thought as a realtor, we're not supposed to do the property management, and is that the broker has to approve for my work as a property manager?
So you should talk to your broker about that. But I will say that the property management agreement that our clients sign is a leasing and property management agreement. So leasing and property management are considered two aspects of real estate. So leasing is not considered property management. But as for what your broker allows, yeah, I would just ask your broker.
Say if the tenant wants to pay directly to the owners, and all we do as a realtor is to just manage issues, like if they have repairs, so we be like a middleman and helping them to solve the issues. Can we do that type of work?
So you definitely want to talk to your broker, but if I were you, I wouldn't. I wouldn't want to get involved in that if I were you, because I don't, you don't want to end up with any type of liability.
What if they are willing to pay for, not like as a property management, if they're giving some kind of hourly pay or per case basis, if they want to pay, should we just take this type of deal? Or they're
in essence, So it goes through your broker, right? Like when you make a commission, it goes through your broker. So you couldn't accept an hourly rate from your client. Like it has to go through your broker. And so again, I'm going to guess your broker isn't going to want you to do that, but you could talk to your broker about it, but you could not accept that money directly. You know what I mean?
Okay. Gotcha. All right.
Anyone else?
Perfect. I have one more question if nobody wants to take this chance. Can you speak about your property management, what you do in terms of if we bring a client, how much do you charge? Is it something you do one-on-one, or can you do it in this conference call? What do you charge?
I mean, maybe someone else has that question. So I was wondering that. So yeah, so our basic fees are, we charge, our monthly management fee is 8%. If it's a client who has multiple properties, then we do 7%. So that's our main fee. Then we have a leasing fee of 1 month's rent.
Okay.
So
What
those
about
are-
the management fees?
8% monthly management fee or 7% with multiple properties. Okay. And then our leasing fee is 1 month's rent, and that's all inclusive, meaning all advertising, photos, etc. Hey, Jim, I wanted to say hi. I saw.
What if the tenants stayed less than a year? Do you have, like if it's going to be more than 2 in a year, you still charge the same 1 month rent?
Yes, we do.
Mhm. Okay.
Yeah, but I mean, we do 12-month leases, so.
I have one quick question, if possible, Abigail.
Yeah.
I'm a realtor and I'm also a landlord. And most of my clients are from Mexico. I represent people, clients from Mexico City mainly, who purchase investment properties, either Austin or the McAllen area on the south of Texas. So is there anything I should be aware of in regards of something specific for international people from other countries who are not residents or citizens or anything, and they're just investors from other country, which that's my niche, that's what I do. But it's kind of interesting to know if there's a particular issue or thing that pertains only to non-citizens or non-legal people. You know what I mean?
Yep, I sure do. So we do have clients who are not US citizens, and what we have to do is, so it depends on the country, and I can't speak for Mexico. Some of them depends on the arrangement they have with US regarding taxes. So the main issue is regarding taxes. And so we have a case, it's a guy who lives in Taiwan. And so we actually have to withhold taxes, and we withhold and pay those to the IRS every month, actually, on his behalf. So some countries that's required, some that's not. I don't know, I don't know in the case of Mexico what it would be, but that would be something that they would want to make sure that they were doing the right thing. And so I'm sure that there are accountants who specialize in this type of thing, and they would be able to guide your clients to make sure that they were, following proper tax protocol.
Yes, thank you. I do set them up with my CPA, and I also have a property manager in most of the cities where I represent clients. But it's good to know you and that you're there. Thank you, Abigail.
You're welcome. Thank you. Anyone else? Last call for questions. All right. Well, thank you all so much for joining me today. I really appreciate you being here. Hope this was helpful. As I mentioned, we will send this out to everybody who attended. So feel free to reach out to me. I believe that Allison put my contact information in the chat box. So if you have any questions about anything relating to property management, rental property investing, more than happy to help. Just feel free to reach out. I hope you all have a wonderful day. I hope you stay safe and warm and dry.
Thank you.
And,
Thank you. Same to you.
And survive our cold snap. Bye, everybody.
Bye.
Thank you.
Hey, Jim.
Hey, sorry about that. I was just exiting out when you said, "Hey, Jim."
Oh, sorry. I was like, oh, you're still there. I'll say hi. So
I have multiple screens here, and I lost my mouse. I can.
I
What?
saw you in the NARPM conference.
How'd you like that?
So I wasn't able to attend all of it. I just had exceptionally, like yesterday I paid owners. I had BNI. So I was like, oh my God. But I
Right.
thought to me, actually, what was her name? Imran, the woman in the morning, Imran Ali or whatever her name
Iman,
is.
right, Iman Ali.
Imran
She's
Ali.
our-
I felt like she was worth the price of admission. That was really good information. I already had a lot of that stuff in the presentation, but I was like, oh, great. Oh, good to know. You can fight the declaration. And oh, good to know about, a couple things. So I
Right.
thought that was helpful. What did you think?
Well, I'm biased because I'm part of the group that put it on, but I think that overall it actually went better than we had hoped. It was fast moving, high energy, a lot of good information. Yesterday afternoon was slam dunk. It was great. This morning was a little bit lower key, but good information. It stayed nice and steady. So I think that the feedback that I've got so far, the initial feedback, which is just cursory, has been very good. We're going to be putting out a questionnaire to all the participants.